clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals is now in session.
Call now cause numbers PD-1236-20 through 1240-20, Brian Ray Middleton versus the state of Texas.
May it please the court. My name is Emily Johnson Liu, arguing for the state of Texas. Just a quick refresher on the facts for the court. The defendant was on deferred adjudication for 3 cases. He then committed 2 new cases. They're all thefts. And the state moved to adjudicate on the original 3. The trial court heard all 5 cases together and ultimately stacked those cases. The Court of Appeals—
Were the 2 new ones, were they separate offenses, or did they occur at the same time? They just charged them twice?
They occurred at different times. They all occurred at different times.
All right. And on the deferred cases, is it the same scenario?
No, it's different victims, slightly different thefts. They were all involving a sort of construction building that never was accomplished. So for the most part, so they're separate victims, different transactions as well. So this is same criminal episode because they're repeated commission of the same offense of theft.
Got it.
And so my argument is that the 2 new cases as a group could be stacked on the old cases as a group because these were not prosecuted in the same criminal action. That phrase is used sort of interchangeably in Chapter 3 of the Penal Code with consolidated prosecution. And my argument is that in Chapter 3, consolidated prosecution really involves the cases being joined together at the time of trial. And trial began on the 3 deferreds long before the others were even committed.
I'm sorry to interrupt you. Just one more point of clarification. Did each of the 5 cases all have separate case numbers, or were they all under the same charging instrument, like the 3 and then the 2? Different
cause number, different charging instruments.
Okay.
Hey, counsel. So now in this situation, on the initial 3 cases, those had not yet been adjudicated, correct?
But there's no finding of guilt. That's right.
Right. And so all 5 cases, the appellant was ultimately found guilty in all 5 cases at the same time, correct?
That's right.
Okay. But the statute says when the accused is found guilty of more than one offense arising out of the same criminal episode prosecuted in a single criminal action, then it runs concurrently. So where is your distinction there with the language of the statute?
So the distinction is with the phrase prosecuted in a single criminal action. He was definitely found guilty of all those offenses at the same time. So the first part of the statute applies. But it's the question is, were these all prosecuted in a single criminal action? Chapter 3 talks about being prosecuted, multiple prosecutions, consolidated for trial. And it envisions a situation where cases are joined in one of 2 ways. Either there's joinder in the same charging instrument, or there's consolidation of multiple charging instruments in time for trial. Written notice has to be given. The defendant's right to sever all has to occur before trial. And trial began on those first 3 cases long before the other 2 were even committed. And so our position is that's too late.
Go ahead. That's right. Go
ahead. I already asked a question. I'll follow up later. Go ahead, Judge Erie.
So my question, counsel, is let's say that for the sake of argument, we were to agree with you. If we did take the position that you were correct about your construction of the statute, would we have to either implicitly or expressly acknowledge that we were wrong in Robbins?
I think Robbins is still distinguishable. That case was not a revocation or a motion to adjudicate. So it's a single plea followed by immediate sentence. And there, the judge bifurcated the hearing, even though there's no sort of legal bifurcation in a plea of guilty before a judge. And so in that case, it was essentially all one unitary proceeding. The per curiam decision from this court in Robbins says that that's good enough. When the cases come together at some point during that unitary proceeding, then it's good enough. And I think Robbins.
How come the same argument can't be made about the situation in front of us now?
So I think that because it's not a unitary proceeding, because you had a deferred adjudication plea proceeding that happened, and then 4 years later you have adjudication hearing on, yes, there is no finding of guilt, but by the time you get to an adjudication hearing, the question is no longer about the defendant's guilt. It's whether or not he committed the violations of his probation. And in addition to that, there's a lot of water under the bridge by that point, essentially. And another reason is that once you have your plea proceeding, your initial plea proceeding, there is a right to appeal. If you don't waive your right to appeal, you don't plea bargain it away, there is a procedure and a process for an appeal from that proceeding. It's just really, you cannot say that it's the same kind of continuous hearing as you could in the situation under Robbins. That's why I think it's distinguishable.
Counsel, when it comes to a situation like this, doesn't the state have the option to proceed with the adjudication, have the judge enter judgment, adjudicate guilt, enter sentencing, and then turn around and accept a plea deal on the other two cases, and then that solves the problem and there's no implication of these issues? Wouldn't that be correct?
That's absolutely correct. I mean, the state has a workaround. The question is whether or not the judge is forced into that situation when that doesn't happen. And our position is that the language should control. And if these truly were not prosecuted in a single criminal action, there really are two cases going on here, not just one lawsuit, then the judge doesn't have to doesn't have to make concurrent sentences.
Well, what's your definition of prosecution then?
So it's really, I think action is probably the more key term. Prosecuted in a single criminal action or a consolidated prosecution means it's one lawsuit, and it means that every time those cases are going to be called, they're going to be heard together. It's that expectation. It means, especially under Chapter 3 consolidation of prosecutions, it means in time for trial. And that's the key thing that's missing here with that second set of cases, is if your trial is broken up into several different stages, they all need to be there together at the same time. And those second set of cases weren't together, didn't begin trial at the same time. Another important thing to remember is that deferred adjudication did not exist at the time that Chapter 3, Section 3.03 came into existence. So that chapter was enacted before there was such a thing as deferred. So we're trying to sort of, put this, square peg in a round hole. So there are certain aspects, like Judge Slaughter was talking about, certain aspects of the deferred that make it seem like, well, maybe this is in play. But it's really a question of what are the most salient characteristics for the purposes of Chapter 3 with deferred. And I think that's why when you look at a motion to adjudicate hearing, the fact that you're no longer, the defendant's guilt of the original offense is not in play is a good reason to make that distinction and say, hey, that's the part of the motion to adjudicate hearing that's really different. And makes a Chapter 3 trial no longer part of the original case, that the original 3 cases were going on. In addition to that, as I mentioned in my brief, the statute really talks in multiple times about this consolidated prosecution being for the purpose of trial. Multiple times it says that throughout this section. And as I mentioned, the state had to give, if you're going to do it in a formal way, state has to give written notice 30 days before trial. The defense, in order to timely sever, has to give that notice before trial. I think if the state, had wanted to give notice at this sort of mishmash hearing, it would have been untimely. And I think that, so it's the same sort of question that we have here. The state couldn't have timely given notice in the same way that a defendant's motion to sever would have been untimely. I think it basically all resolves to the same sort of question.
So are you saying, I guess, that the motion to adjudicate is one action and the guilty pleas are a different action?
Yes, they might have been considered together during the same time at the same hearing, which judge has inherent authority for judge's convenience to hear matters together. That hearing was definitely combined, but this was not a consolidated prosecution. This was not prosecuted in one single criminal action.
Because there were different types of actions.
Yes.
Counsel, how do you define same criminal episode?
So same criminal episode is defined in the penal code in chapter 3, both, different, could be the same transaction or could be repeated commission of the same or similar offense. Because all these cases were theft, that they fall under that second definition of same criminal episode.
I have a question for you, just to make sure I understand. All of these were state jail felonies, is that correct?
Ultimately, yes, they're all state jail felonies.
Okay, so they're all 2-year sentences. And what the trial judge did, and correct me if I'm wrong, is he stacked all of them. It'd be 2 + 2 + 2 all the way to 5. Are you saying that we should uphold that ruling, or should it just be 2 + 2? The last, okay, you understand what I'm saying?
Yes, I do. So I'm not contesting that the first group of 3 were consolidated, or that the second group of 2 were consolidated. I'm just saying he could have stacked 2 on 2.
Okay, thank you.
Unless there are any more questions, I've reserved 3 minutes for rebuttal.
Thank you, counsel.
May it please the court. My name is Tom Abbott, and I am for the respondent, Brian Ray Middleton. Now, I wanted to address one thing at the very beginning. The state is arguing essentially that the deferred adjudications were in some essence completed already, in that the defendant had entered pleas and had been placed on deferred adjudication probation. And because that order was appealable, that was somehow complete. The problem with this argument is that deferred adjudication is not in itself a sentence. And under Robbins, a plea is not complete until the defendant has been sentenced. What you actually get with deferred adjudication is essentially a very long plea proceeding where the legislature has built in an avenue for the defendant to earn some forgiveness from the court such that they might avoid a felony conviction. If they complete that probation successfully, the finding of guilt is never entered, and the charges are dismissed. And so the deferred adjudication probation itself is not a sentence. It is just an extension of the plea proceeding so that that defendant can in some ways redeem themselves.
But counsel, can I interject with a question? It seems to me that there is a separate pleading that's typically filed at the motion to adjudicate phase, and that is a motion to adjudicate that typically is going to allege different facts than the facts that are alleged in, for example, the original indictment to which there was a plea entered at the time that the deferred adjudication began. And so, it seems to me you've got really a different pleading trying kind of a different action at that time than the guilt or innocence. And as I understand your argument is that, well, guilt hasn't formally been the finding of guilt hasn't formally been imposed, but typically before entering a deferred adjudication order, a trial judge will make a determination, for example, that the evidence is sufficient to sustain a finding of guilt, and only reserve that formal action of actually entering a formal finding of guilt if later on a pleading is filed, as I imagine was in this instance, alleging some other circumstances. And so in a way, help me understand why in these circumstances you think that that's still just a continuation of the same, or that it's the same proceeding when all that's being determined is really a separate issue and not the guilt of the person.
Well, the issue is, judges, that the legislature has laid out a procedure whereby a plea can be taken and completed. As this court has laid out in Robbins, the judge hears the case, and it's also with ex parte FAR. The judge, calls the case, takes the plea, admonishes the defendant, and enters the plea in the sentence. If you look at ex parte FAR, it's a little bit of a procedural issue, but what the judge did in that case was call each individual cause number separately, go through the whole process, and once it was complete, then he started stacking. In order for the stacking to occur, the plea proceeding has to be complete before you move on to the next plea proceeding. And the problem with deferred is that plea proceeding is not complete, regardless of what issues are raised in a motion to adjudicate, until that process has been completed and the plea of guilty has been entered against the defendant. I think that what the state does, and a lot of the case law that applies to this, applies to straight probation, which is where the defendant is given a sentence, but that sentence is suspended. It's a formulaic matter, but it's how the legislature wrote it out. And it's not unclear, it's not ambiguous, and it's not absurd. So the other thing I wanted to point out to the court.
Counsel, I'm sorry, I had a little trouble with my microphone. I was going to ask you, what do you make of the legislature's use of the word action then? The state has argued that the use of action suggests something broader than something like a simple proceeding, the similar proceeding. Does it cut both ways, or do they have a point?
I don't believe that I don't believe that applies here, because while the actions began at separate times, they were implicitly joined together when the defendant in this case entered an open plea of true to the motions to adjudicate, and guilty to the new charges. Essentially, he had a right to have those heard separately, which he waived by dealing with it all at once. And because the court merged the actions together, I'm saying that it doesn't really matter, because none of them were completed until the very end of the hearing, when all of them were sentenced at once.
So
Now-
a motion to adjudicate is not a separate action from a guilty plea.
No, Your Honor, I don't believe that it is in this instance. The reason being is that the motions to adjudicate could be filed for a multitude of reasons, from not paying the fees, fines, and court costs, attending classes, failing to report, or new offenses. Here, they were just new offenses. So the motions to adjudicate essentially tied the two together to some extent.
So if the motions to adjudicate had alleged any other violation other than these new thefts, Would they be separate actions?
If the court heard them separately.
Oh, so they'd have to be heard separately no matter what.
I believe under ex parte FAR, it's very clear that they have to be done separately. I mean,
So
in that
action is a proceeding?
yes, the action would be, I guess, the calling of the cause number and then going through that proceeding before, which was what happened in ex parte FAR. He went through the first one, went to the second one, then the third. And I'm imagining that whole hearing, well, all those hearings combined probably took about 15 to 20 minutes, but they were separate and distinct actions because they were all resolved at separate and distinct times. Additionally, with regard to cumulative sentences, the defendant has an absolute right to have them run concurrent unless he explicitly waives them, which did not happen here. Instead, the judge went ahead with it and stacked them all up, but he didn't have a right to do so. Let's see. I also have, I also want to point out that 303 has been amended multiple times. Exceptions to this rule have been explicitly carved out, but theft is not something that the legislature has ever carved out an exception for. It's only been for very egregious offenses such as sexual offenses against children and drunk driving instances that result in death or injury. If the legislature wanted to carve out an exception for people that had committed numerous instances of fraud or theft, it would have done so at some point.
Mr. Abbott, what is your response to the prosecution's argument that at the time that 3.03 was created, we didn't have something like deferred adjudication? So the court was, not the court, the legislature was describing something that it clearly understood as a single criminal action at that time without anticipating what was going to happen in the future, legislatively speaking, with the development of the deferred adjudication process. Do you have an answer to that?
I do. I think the issue is with deferred adjudication itself, in that the legislature created that as a means whereby a defendant who, for all intents and purposes, was otherwise guilty, might get some mercy from the court and avoid a criminal conviction. I think that when 303 was enacted, all we had was straight probation, which was a suspension of the sentence itself, not a suspension of the finding of guilt. And I think that the legislature intentionally structured it this way because deferred adjudication is not meant to be a punishment. It's meant to be a way where a citizen can avoid punishment and can avoid the problems of having a felony or criminal conviction against them altogether. And so it doesn't really apply in this instance of whether or not we can stack these sentences simply because of the way it was structured to begin with.
Well, there are other go ahead.
I'm sorry. They don't really avoid punishment, do they?
On deferred
adjudication?
Well, the deferred adjudication probation is not a sentence.
Right, but isn't there a difference between a sentence and punishment? They have to pay a fine, they have to do community service, they have to do this, that, and the other. None of that's punishment?
Not as the legislature created it. Essentially, the punishment, it's the trade-off in deferred itself. You place a defendant on deferred. Any violation that results in their guilt being entered subjects them to the entire punishment range. Essentially, deferred adjudication is more like an open plea with a really long timeline, in that if the defendant messes it up, say on a first degree felony, let's say, aggravated robbery, placed on deferred, any little thing can, when he comes back, the judge can sentence him all the way up to a life sentence. That's the trade-off that the legislature created. And whereas with straight probation, which is what a lot of the case law talks about, that defendant's already been sentenced. If he messes up the probation and they have to remove that suspension, there's no argument as to how much time this person is getting. It's already laid out there on the judgment. Whereas deferred, it's not the same.
Counsel, if we were to read the statute the way you're asking us to do so, wouldn't this be a good tool for both sides to be able to use in negotiations? Because, for instance, in this case, you've got the appellant pleading true to, or having pled guilty to these 3 theft offenses, going forward with an adjudication hearing. He could have pled true without pleading guilty, and then had the adjudication of the 3 offenses, and then had a separate deal on the other 2, or force the state to go to trial to prove it beyond a reasonable doubt. So there could have been that. But then this could be used as a tool in negotiation, saying, okay, well, we can handle it all in one proceeding, knowing that it will all run concurrently. And, this is a way to resolve all of this at once and be done with it. And both sides maybe get what they want out of it.
Well, yes, Judge. In fact, if this court goes with what the state is asking, the harm that will be created is that the defendant, and to some extent the state, won't have notice of the full ramifications of any plea agreement that is reached. Right now, we know that if we deal with this all in a holistic manner, my client is getting a concurrent sentences. Doesn't matter how many sentences he gets, but they're all going to run the same. If this were to be removed and whenever a defendant comes up with a motion to adjudicate and new charges, we go to the court and deal with it all at once. We have no idea what the actual result will be. Okay, we are always taking a gamble, no matter how we try to resolve it. If we try and resolve it piecemeal, we can get stacked. If we try and resolve it all together, we can still get stacked. Now, there are certain exceptions to this. I mean, as I mentioned earlier, sexual offenses against children, or drunk driving incidents that result in death or injury, you kind of have to go to the court to begin with when you're discussing these plea agreements and ask, are you going to stack them? Or at least the defense attorney, in my opinion, should.
Can't you negotiate that? Can't that be negotiated as part of a plea agreement?
Well, yes and no. The problem is that the trial court is the only authority that has the discretion to stack or not. I can work out an agreement for my client with the state where we agree that these are going to run concurrent. And if we go through that and the trial court says, no, I'm not going to run them concurrent, then those pleas would be withdrawn. However, if that is not addressed explicitly under this instance, then the trial court may have some opportunities to stack those sentences. Additionally, it works the same both ways. So if I make individual plea agreements for my client and we take them all to the court, and then but we don't address whether or not these are all supposed to run concurrent, and the trial court starts running through each cause number individually, the trial court can still stack them regardless of the plea agreement, because we didn't explicitly address that issue. But right now, as the law is right now, if we didn't explicitly address that issue and we have them all heard at once, they're concurrent sentences no matter what.
So I have one more question. I can't remember from what I've looked at this case already, but was there an objection to the stacking that was made at the time that it happened?
No, there was not an objection. However, that is a waiver only right. meaning that, and I believe it was under Miranda, it's a Miranda waiver only right in that it has to be concurrent unless the defendant explicitly says, yeah, you can go ahead and stack me. I don't know why any defendant would actually do that, but that's the way the right is laid out.
Thank you.
You're welcome. Now, finally, one other point I wanted to make in regards to harm is that I think that if this court does what the state is asking, it will largely remove that forgiveness structure created by deferred adjudication, meaning that the probation itself will become a sentence and a punishment, as opposed to an extended plea agreement where the defendant is given a chance to redeem himself. This will kind of undo the legislature's intention, in the sense that because the plea will ultimately be seen as complete once he's placed on deferred adjudication, I'm not exactly sure how you then go through the process of dismissing the charges and allowing the defendant to non-disclose that agreement at a later date, because effectively this would be counting as a sentence itself, if that makes sense. And finally, I think that the other harm with this is just the backlog. The legislature created this standard of concurrent sentences in an effort, it appears, to mostly resolve cases as quickly as possible. You can take 4 cases to the court, plea them all at once, you get concurrent sentences, all 4 cases are resolved. Whereas if the defendant is looking at, maybe they're going to stack these cases if I try and plead them all together, I'm going to drag my feet and make them deal with each individual one, so that way I can make sure if I do get stacked, they had to earn it. And I think that, going with what the state is asking for is just going to slow the entire process down. Thank you very much.
Thank you, counsel.
May it please the court. So I'm not asking for deferred to be completely changed. It's still going to have its essential natures. But what I'm saying is, and even though there are statements that this court has made in opinions that, in some respects, it's a continuation or a stopping or a stilling of the proceedings. I'm just saying, for the purposes of Chapter 3 consolidation, this is not the kind of continuation of the same hearing that makes it enough to be the same criminal action. So I'm not going to change the way deferred will operate. It still has the same, there's not going to be a finding of guilt. There's not going to be a sentence in the same way that you're going to prison.
Counsel,
Yes.
counsel, if I understand correctly, defense counsel wants us to treat deferred as if it were just kind of a pause, as you were saying, in the proceedings from the original case, and to treat the difference in years as if it were just, a pause. If a judge hears a plea on one day and says, we're going to adjourn the court for the day, without finding it, we're going to adjourn the court for a day. I'll see you back in court at 8 o'clock in the morning, and sentences the defendant for yesterday's offense at that point, and also takes pleas on other cases, new cases by the defendant, would he be able to stack those?
I think that's like a continuance. That's much more like the same hearing. I think that's much more like a Robbins type situation. And so it would be strange that you wouldn't I mean, obviously you wouldn't have had it at the pleading stage. The cases, the cause numbers wouldn't be the same at the pleading stage. But, you know, perhaps in a strange situation like that, it could still be just in time because the phase of guilt was still open. Maybe he could have, you know, taken back his plea, possibly. I think that would be an extremely rare situation.
Thank you.
Also, what I'm suggesting is not going to be any more unclear than the way things are operating right now. LaPorte enables all of this, a consolidated prosecution to happen without anyone acknowledging it and saying so expressly. No written notice, defendant is waiving that right, and so it's sort of all implicit. And Robin's extension out there to a plea proceeding that's still ongoing and you can consolidate at that point does sort of leave things unclear. And I think this case provides an opportunity to bring clarity so that everyone can know what is going to happen in that situation. And if the cases are not going to be combined at the stage of pleading or during that a continuous, like during the original guilt phase of trial, if they haven't been joined by that situation at that time, then they cannot be consolidated later on.
Do you also agree with counsel for the defense that this kind of error is not required to be preserved by an objection at the time of trial?
That's what this court has said, is that it's a Marine type 2 category of error. Now, in keeping with that, if it's really truly something that doesn't have to be preserved, it should be something that's really clear. It should be a rule that everyone, you know, would know whether we're talking about one criminal action or multiple criminal actions, whether these really can be stacked at the same time or not. And that's why I think, you know, setting a rule that it has to be at the time of the first trial setting, they have to be together, that would support this court's decision that that's a category 2 type of error. Another kind of sort of strange oddity that can sometimes happen with deferred is that, you know, you might have new cases where the defendant wants to have a jury trial on his new cases, and judge is considering a deferred adjudication at the same time. So you have one trier of fact determining the motion to adjudicate, a different trier of fact considering the new offenses. I think it would be really hard to say that these are all one same criminal action. And that is the situation that's happened in the cases in the Court of Appeals cases that have addressed this issue. Interpreting criminal action as just meaning hearing really gets far away from the legislature's meaning and understanding in Chapter 3. This sort of mix and matching of procedures at different stages is not what Chapter 3 consolidated prosecution means. And it can't mean just a joint hearing. Unless there are any more questions, then
I have a quick question. I haven't thought it through. If the defendant's on deferred for a couple of cases, he comes to court and the judge puts him on deferred for the new cases, and then later on there's a motion to adjudicate on all of them on the same, could they be stacked? Could those sentences be stacked?
I think they could. I think that's too late. Once you are past that, the original plea proceeding is done, you're placed on deferred. I don't think you can join any other new cases. Even if at that hearing, he's continuing the defendant on deferred adjudication for the original cases, it's still that proceeding. You've had a motion to adjudicate, you have a different pleading, you have a different question in front of the judge. You're not part of that original guilt proceeding. So I think that's different, and I think they could be stacked.
Thank you, counsel. Any other questions? The case is submitted, and the clerk will adjourn the court.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.